Well, thank you very much. Good afternoon, everybody. My name is Vince Farhat. I'm a partner at Jeffrey Mangels, and we want to thank the Beverly Hills Bar Association for the opportunity to meet with you today. According to Johns Hopkins University, as of this afternoon, there are about 5.7 million COVID cases worldwide, resulting in over 356,000 deaths. Here in the United States, there are almost 1.7 million cases, and over 100,000 Americans have died. And today is a grim milestone. We did pass the 100,000 mark today. I think it's fair to say that we live in unprecedented times, and never before in modern history has the United States voluntarily shut down our entire national economy in an effort to stop a virus pandemic. Entire industries are shuttered, tens of millions of people are out of work. Payrolls have dropped by over 20 million workers, which wiped out in a single month an entire decade of job gains. Manufacturing output fell almost 14% last month, which is the largest decline on record since the year 1990. Now businesses are starting to reopen. And as businesses are starting to reopen, governments at every level, federal government, state government, local governments are struggling to try to help companies and people in need. And we all know about the CARES Act. Last month, the federal government added another $460 billion in relief to the already passed $2 trillion in government aid. And as we speak, Congress is working on a package of further aid. Now, today's program is not about the economic challenges we face. This presentation is about the law enforcement investigations that will be ramping up in the near future. In passing the CARES Act, the federal government created enormous incentives for companies to apply for economic stimulus funding to alleviate the economic impacts of the pandemic. With trillions of dollars in government aid being dispersed, law enforcement agencies already have started investigating companies and business owners in connection with their receipt of stimulus funding and grants. We're going to talk about that today. For example, less than 2 months after the passage of the CARES Act, DOJ already has brought 8 or 9 criminal cases for alleged fraud and false statements in connection with the SBA's Paycheck Protection Program, the PPP program. And that's really just the beginning of what we anticipate will be years of government investigations and enforcement actions. Today's program is going to be in 3 principal parts. First, we're going to start the program with a focused overview of the CARES Act programs and the government oversight provisions that are included in those programs. Secondly, we'll talk about current trends in COVID-19 anti-fraud enforcement by federal, state, and local law enforcement agencies. And lastly, in the last part of the presentation, we'll highlight why companies receiving federal aid should be positioning themselves now to demonstrate compliance and manage enforcement and litigation risk. At the end of the program, we'll leave time for questions. We would ask you to share information or questions on the chat or Q&A function on your Zoom application, and we'll answer questions at the end. And if we don't have time to answer every question, we're always happy to take those offline. I'm joined today by my colleagues Justin Anderson and Sina Maximini. Justin is a member of our litigation group. His practice focuses on commercial litigation, corporate defense, and investigation matters. He earned his law degree from Duke University School of Law and attended undergrad at the University of California in San Diego. Sina is a member of our government group. His practice focuses on assisting clients in navigating regulatory, zoning, and environmental issues. He's part of the legal cannabis group as well. He earned his law degree from the University of California, Berkeley School of Law, where he served as a member of the California Law Review. So with that, let's advance to the next slide. Let's get started. I'll turn the program over to Justin, who's going to give us an overview of the CARES Act. Justin?
Thank you, Vince. As I'm sure you are all well aware, during this current pandemic, the government's main focus has been on stimulating the economy, as many businesses are shut down and workers left without a job. The CARES Act provides over $2 trillion in financial assistance to all corners of the economy and includes financial assistance in the form of direct loans, loan guarantees, and investment programs. Please advance the slide. The CARES Act really has 4 main programs through which it purports to aid businesses that have been most impacted by COVID-19. The Paycheck Protection Program, the Economic Injury Disaster Loan Emergency Advance, SBA Express Bridge Loans, and SBA Debt Relief. First, the most talked about program under the CARES Act is the Paycheck Protection Program. The PPP is a loan designed to encourage employers to keep workers on their payroll and to help small businesses cover their expenses. For example, payroll, mortgage, rent, utilities in the near term. PPP loans are designed for small business owners, which generally means a business that has less than 500 employees. Companies with more than 500 employees can also be eligible if they satisfy the small SBA employee-based size standards for the entity's primary industry. But, of course, the public has taken issue, perhaps rightly so, with certain large, well-funded companies that have qualified under this arguable loophole. For example, Ruth's Hospitality Group, a company with 59 locations and $87 million in cash on hand, reported getting $20 million in PPP loans. Similarly, Shake Shack, a publicly traded company with 8,000 employees and an annual revenue of nearly $600 million, received $10 million. I'm sure you've all heard of these issues. Given this, with the second round of PPP funding recently authorized by Congress, the Treasury has emphasized that public companies have an obligation to certify in good faith that they need the money and warn that they should be prepared to demonstrate that need upon request from the SBA. The SBA went on to caution that it is unlikely that a public company with substantial market value and access to capital markets will be able to make the required certification in good faith, and such a company should be prepared to demonstrate to the SBA, upon request, the basis for its certification. So allowable uses for loan proceeds include payroll costs, which include paid leave, severance, retirement, and payroll taxes, as well as insurance premiums, interest on mortgage obligations, rent, utilities, and other permitted uses for SBA business loans such as inventory or supplies. Now, the second program under the CARES Act is directed towards small businesses, and it is the Economic Injury Disaster Loan Emergency Advance. This loan advance provides up to $10,000 of economic relief to businesses currently experiencing temporary difficulties. Again, this program is for small businesses with less than 500 employees, which would include sole proprietorships, independent contractors, and self-employed persons, private nonprofit organizations, or 501c19 veterans organizations affected by COVID-19. The funds are intended to be made available within days of a successful application, and this loan advance will not need to be repaid. Turning to the third program, SBA Express Bridge Loans are also a source of economic relief under the CARES Act. This loan program enables small businesses who currently have a business relationship with an SBA Express lender to access up to $25,000 quickly. These loans are designed for situations where a small business has an urgent need for cash while waiting for a decision and disbursement on an economic injury disaster loan. To be eligible, the loan applicant must demonstrate, and the lender must document, that the applicant had an operating business as of March 13th, 2020, and that the applicant has demonstrated that it has been adversely impacted by the COVID-19 emergency. Please advance. The SBA is also providing debt relief through CARES Act funding. This is just what it sounds like, debt relief for small businesses. Under this program, the SBA will automatically pay the principal, interest, and fees of certain current 7A, 504, and microloans for a period of time. If a borrower is eligible for this program, debt relief should be provided automatically by the Small Business Administration without the borrower taking additional action. Under the CARES Act, the Small Business Administration is directed to begin making payments within 30 days of the date on which the first payment of an eligible loan is due. Now, the Main Street Lending Program is another avenue through which small and mid-sized businesses can obtain funding needed due to revenue shortfalls caused by COVID-19. This is a Federal Reserve program, and the Federal Reserve will be purchasing up to $600 billion in loans. Last, the CARES Act also provides $175 billion in relief funds to hospitals and other healthcare providers on the front lines of the coronavirus response. This funding supports healthcare-related expenses or lost revenue attributable to COVID-19 and ensures uninsured Americans can get testing and treatment for COVID-19. Please advance the slide. So to get a feel for the economic impact that COVID-19 has caused and the ways in which Americans are relying on the CARES Act, we've compiled a few statistics here. Now, I'm not going to read through these, but it's clear from just a glance the impact COVID-19 has had on Americans and the dire need for funding like the CARES Act. Having outlined in general the economic relief programs provided by the CARES Act, I will now turn it over to Vince to discuss the oversight and enforcement measures related to disbursement of funds made through these programs.
Thanks, Justin. So as Justin indicated, the CARES Act established a number of new enforcement bodies that are embedded in the legislation itself. And these are new enforcement bodies in addition to traditional law enforcement bodies, such as the FBI, the SBA Office of Inspector General, and the various civil division components of the department.
It looks like Vince is frozen here.
Did we lose Vince?
It looks like is he frozen? Well,
It looks like Vince lost connection or something.
Okay, well, I can take over on this slide until Vince regains connection. So, as an overview for CARES Act enforcement, businesses should expect to receive significant oversight and enforcement activity involving CARES Act funds for years after the COVID pandemic ends. There's no shortage of oversight. There's enforcement built into the CARES Act itself, which established the enforcement bodies, which we'll discuss in the next two slides. And it looks like Vince is back.
Back. Well, welcome to the world of working from home. And apparently a relative of mine is on the internet, so it's stolen some bandwidth. Thank you for that, and I apologize. But as I was saying, parallel proceedings are where you have sometimes criminal as well as civil and perhaps administrative proceedings all going on at the same time with these various agencies sharing information. And when you're navigating an investigation that involves other agencies, you really need to be mindful that what you do in the context of the criminal investigation could have an impact on the civil investigation and vice versa. And that's something that I wanted to make sure we mentioned at the outset, because based on my experience, I do believe that we'll see a number of investigations that will be multi-agency, FBI, SBA, and the various other agencies that are now going to be on the scene. So what are the new agencies? First, the Inspector General for Pandemic Recovery, SIGPR. This is a new Inspector General under the Office of Inspector General Act. All federal agencies typically have an Office of Inspector General. This is a new Office of Inspector General. It will function for 5 years. It will have a $25 million budget. It will have subpoena authority, and importantly, it will be able to refer cases to other law enforcement agencies. The head of this agency will be the Inspector General. Brian Miller, who is an experienced Inspector General from another agency and currently White House counsel, is the nominee. It has to be confirmed by the Senate. But the Inspector General for Pandemic Recovery will have overall responsibility for coordinating audits and investigations. And we do anticipate it will be a robust body with far-reaching influence in these types of investigations. The next body that was created for government oversight is the Congressional Oversight Commission. This agency, or this body, is a oversight that will provide oversight for the Treasury Department, Federal Reserve, and the various agencies' implementation of the CARES Act. They'll be empowered to hold hearings. As part of those hearings, they can take under oath penalty of perjury testimony. They can compel production of documents and witness testimony. And they're required to furnish regular reports to the Congress. So the Congress will be very much in the loop. The Commission's authority would terminate on September 30th, 2025. So as you can see, we're in for the long haul. The Congressional Oversight Commission, like the Inspector General, will be a public agency and will have public hearings. Next slide, please. Thank you. Another body that was created under the legislation is what's called the Pandemic Response Accountability Committee. I'm not sure what that, I suppose we could call it the PRAC or the PRAC. It's tasked with, really has the broadest oversight and enforcement powers of the three oversight bodies established by the CARES Act. It's tasked with helping the inspectors general safeguard CARES Act funds, and their mandate is to detect and prevent fraud, waste, and abuse and mismanagement and to mitigate risks that cut across programs and agency boundaries. So notably, their purview isn't just fraud, but also waste and abuse, which is broader than just fraudulent conduct. The PRAC's functions include a comprehensive audit and review of charges that are made to federal contracts under the CARES Act authorities. And they have an $80 million budget, and they may refer investigations to the DOJ for criminal or civil investigation. And even without the DOJ, the PRAC is going to be able to conduct independent investigations, hold public hearings, and issue subpoenas for both documents and testimony. So it's a very robust enforcement body. One thing to bear in mind, in addition to these enforcement bodies and traditional enforcement bodies like DOJ, SEC, and SBA, you're going to have a significant amount of overall congressional oversight. We've already seen, for example, members of Congress who have written letters to the Treasury Secretary and the Federal Reserve indicating that they're going to be watching very carefully as the government hands out these funds. For example, Elizabeth Warren, Senator from Massachusetts, sent out a very strongly worded letter making it clear that the Congress does expect to exercise its purview to provide oversight. So we can expect that the political branches, as well as enforcement agencies, will be involved. In fact, last month, top members of Congress asked the SBA Inspector General to investigate the implementation of the PPP after reports, as Justin referred to, that certain larger companies have received a preferential or might have received preferential treatment from lenders at the expense of smaller businesses. Later in the presentation, we'll talk about some action that was taken in this regard, but please bear in mind that in addition to the official oversight bodies that are created and have been created, you're going to have a significant amount of congressional oversight, as well as oversight from members of legislatures throughout the states, including California. We can anticipate that the California legislature, which already has very robust oversight responsibilities in working with the California Attorney General's office, will also likely provide oversight and hearings of some sort with respect to allegations of misconduct, fraud, waste, and abuse. So we can certainly expect to see this both on the federal and the state level. So obviously, these enforcement bodies create a number of potential intersection points between law enforcement and companies receiving aid, and the lawyers that represent those companies. So moving to the next slide, I want to introduce this next topic that Sina is going to be speaking on. Government agencies aren't waiting until this crisis is over to start investigating companies and individuals for suspected fraud. Federal, state, and local law enforcement officials already are moving fast. Every day we're seeing new enforcement actions. And so this next module, we're going to talk about current trends in anti-fraud enforcement. Now, why do we care? Why is it relevant to look at the cases that have gone through so far? Well, understanding what law enforcement's doing today is critical. Companies that receive federal aid can use current law enforcement trends to help forecast what they should be doing to mitigate their potential enforcement and litigation risk. In other words, understanding what law enforcement is doing now is going to help companies spot issues around their own potential compliance risk. So with that, I'm going to turn the program over to Sina Samimi, who's going to walk us through current trends in enforcement.
Hey, thank you, Vince. So with that background, we're going to jump into everything that the government's done so far with respect to enforcement. We're going to give you some interesting examples. There's some that are pretty juicy, and it'll make you scratch your head about what these people were thinking. So on March 16th of 2020, the U.S. Attorney General directed all U.S. attorneys to prioritize investigation and prosecution of COVID-related fraud schemes. In a March 19th follow-up memo, each U.S. attorney was directed to appoint a COVID fraud coordinator, which would have three main duties. One would be to serve as legal counsel for federal judicial district on coronavirus matters. 2, direct prosecution of coronavirus-related crimes. And 3, to conduct outreach and awareness. So you can see the quote there from Attorney General Barr in his memorandum. And the key point there is they're not going to tolerate behavior that would take advantage of the COVID-19 crisis. So they're going to remain vigilant in detecting, investigating, and prosecuting wrongdoing related to the crisis. In particular, There have been reports of individuals and businesses selling fake cures for COVID online and engaging in other forms of fraud. We're going to get into those details. Reports of phishing emails from entities posing from the World Health Organization, CDC, and prevention, and reports of malware being inserted onto mobile apps designed to track the spread of the virus. The pandemic is dangerous enough without wrongdoers seeking to profit from a public pandemic, and this is the sort of conduct that cannot be tolerated. And then he goes on to explain what he did with respect to the Attorney General's office. So now what will become clear as we go into some of these cases is the evolution of the enforcement. The initial cases focused on things like the fake treatments, and then there was an expansion later on to financial fraud. So we'll see how things have evolved even in the short period of time between March and May of 2020. So moving to the next slide here. This is one of the first reported federal enforcement cases that would fall under the category of fake treatments. So on March 21st in Texas, operators of the website coronavirusmedicalkit.com allegedly engaged in a wire fraud scheme seeking to profit from the confusion and fear surrounding the coronavirus. Their website claimed to offer consumers access to WHO vaccine kits for $4.95 shipping charge, when in fact there are currently no legitimate coronavirus vaccines. So that was just a complete fraud. And the US District Court issued a temporary restraining order to block public access to the website. That happened pretty immediately. And a quote from the Assistant Attorney General here, the Department of Justice will not tolerate criminal exploitation of this national emergency for personal gain. We will use every resource at the government's disposal to act quickly to shut down these most despicable of scammers, whether they are defrauding customers, committing identity theft, or delivering malware. Now we have 3 more examples of federal fraud prosecutions. These were end of March and early April. On March 25th, DOJ complaint alleges that a Southern California resident had claimed to have a patent pending cure, a treatment that prevents coronavirus infection, even though, again, there's no specific antiviral treatment for COVID-19 and no vaccine to prevent infection. In this case, the US attorney was quoted as saying, "During these difficult days, scams like this are using blatant lies to prey on our fears and weaknesses. While this may be the first federal criminal case in the nation stemming from the pandemic, it certainly will not be the last. I again am urging everyone to be extremely wary of outlandish medical claims and false promises of immense profits. And to those who perpetrate these schemes, know that the federal authorities are out in force to protect all Americans, and we will move aggressively against anyone seeking to cheat the public during this critical time." So, you know, they're obviously signaling that they're ready to enforce against anyone who goes against these types of, to try to utilize this to their advantage. Then again, on March 30th, there was a case in New Jersey where a man was arrested. This isn't quite a fake treatment. This is more of an orchestrating a scheme to defraud the healthcare benefit programs that were related to testing. This person is alleged that he offered kickbacks in exchange for medically unnecessary tests. And then finally, on April 1st, there was another man charged with mislabeling and unapproved treatments for vaccines. He repackaged pre-existing Trinity remedy kits as Trinity COVID-19 SARS kits, even though the kits had not been approved by the US Food and Drug Administration to treat the COVID-19 or for any other use.
Sina, one point that I wanted to interject, and it seems that some of these earlier cases were sort of consumer protection oriented, some civil, some criminal, aimed at protecting the public from false bad business practices and fraudulent business practices, as opposed to fraud on the government for receiving the money. Is that right?
Yeah, absolutely. And we're going to see some of the evolution into the later, how that's changed over time. And then you see, we haven't even gotten to some of the financial stuff and the price gouging yet, but we're going to get to that later on, but you're absolutely right. So then you have a couple more cases here that would fall under the category of fake treatments again. So you have a Georgia resident who was arrested for selling illegal products that we're claiming to protect against viruses. And again, Vince, you're right. This is mainly meant to protect the consumers who would be going out there and buying these things. And obviously they're not effective, or they're not proven to be effective. And then the next day in Washington, D.C., a man was arrested for fraud for attempting to sell millions of non-existent respirator masks to the Department of Veterans Affairs. So there was a criminal complaint that alleged wire fraud against the defendant, and there were a series of fraudulent misrepresentations in an attempt to secure orders from the VA for 125 million face masks and other personal protective equipment, which that's known as PPE. I'm sure you guys have all heard that abbreviation. And so it would have totaled $750 million. This case is different from the fake treatment cases because these relate to situations where products that would otherwise be effective to protect against the virus, like masks, they were simply sold to people for millions of dollars, but none of the products actually didn't exist. On April 27th, in a very similar set of facts, it's not reflected on the slide here, another scheme was uncovered where defendants were arrested for seeking over $4 million in sales of masks that were non-existent. And in one of these cases, they actually had advertised with boxes that were supposedly they contained these masks inside of them. But in fact, the boxes were empty. When they did the investigation, it was shown that the boxes didn't have anything inside of them. So this slide is interesting because on April 14th, the FDA and the FTC issued warning letters to 3 sellers of fraudulent COVID-19 products. But now we're spanning against across different areas. And you can tell that the agency's effort here is to protect both people and pets. So the first one is a CBD related scheme, and there was an online CBD store offered unapproved and misbranded CBD products with misleading claims.
Tina, let me ask, since you're part of the legal cannabis group, just to make sure we're all on the same page, CBD is a cannabis. What does that refer to?
It's cannabidiol. It's one of the 2 active ingredients, or there's many active ingredients, but one of the 2 most well-known active ingredients. The other one being THC, which is the one that makes you high, and CBD is the one that doesn't make you high, but it does have a lot of therapeutic benefits that are touted by the industry. But there's only been a couple of these CBD related treatments that have been approved by the FDA to date. But on this note, and specifically related to COVID-19, there are, and again, you're right, Vince, I do a lot of cannabis regulatory work in my practice. And so I kind of keep my finger on the pulse of what's going on, not only here in California and in the US, but even worldwide. And it just so happens that countries like Australia, and they're not the only ones, there's some other countries where they're actually approving real tests to be done to examine the viability of CBD in the treatment of COVID-19. So it may be in the pipeline that actually some CBD products are going to come out that do have some proven benefits, but we're not quite there yet. And so in this regard, the US government is cracking down on those claims. And then the second example is there's a church here that sold dangerous chlorine dioxide products known as the Miracle Mineral Solution. And again, that was touted to be for the prevention of COVID-19. And the FDA warned consumers not to purchase or drink chlorine dioxide products sold online as medical treatments because these pose significant risks to patient health. Now, there's a joke to be made here about Trump's recent statement regarding similar products, but I'll let you consult your regular late night comedians for that.
Thank you.
So the last one here on this slide is there's a holistic pet store that again made misleading claims, and this is just an example of how the fraud goes beyond human treatment, and enforcement action has been taken against companies providing services and purported treatments to animals as well. And here on this slide, we have 2 more examples in Florida of things that we've seen already, fake treatments and non-existent products. One of them, there was a temporary injunction that was issued that halted the defendant's sale of an unapproved treatment product. And in that case, the US attorney stated that We will zealously pursue perpetrators of fraud schemes. And they're going to continue to do that as things go on. And pretty soon I'm going to be transitioning over to additional types of non-fake treatment related things. On April 21st, the DOJ had a press release where, and this is important to note because Vince is going to get into this a little bit later on in the presentation, but you don't only need to worry about enforcement coming from the government authorities. You also need to be aware of whistleblowers and people complaining and calling. And so the FBI's Internet Crime Complaint Center, it received and reviewed more than 3,600 complaints related to COVID-19 scams. And now, who knows how many of these they actually went in and started enforcement actions on, but that's obviously a huge number of complaints, many of which operated from websites that advertised fake vaccines and cures, or they operated fraudulent charity drives, delivered malware, or hosted various other types of scams. So when these complaints were received, the cooperative effort has disrupted several different illegal schemes. One of them was related to the American Red Cross, as you can see there. There were also other websites that were meant to trick people, and even websites of legitimate companies and services that were used to facilitate the distribution of malicious software. So we have kind of, it's kind of a red flag, and it'll preview some of the issues that Vince is going to cover later on in the presentation. And finally, here, before we get onto some different styles of financial enforcement, in late April, there were, in Washington, D.C., there was a seizure warrant authorizing the seizure of a domain for coronaprevention.org. The warrant alleges that the owner of the Corona Prevention posted it on sale on a hackers forum, stating that on the forum, this domain would be an effective way to sell high markup, in-demand products. And so this actually relates to some, we're going to get into some price gouging examples further down the line, but it's kind of a preview of that, and it relates to people hoarding products and wanting to sell them at a higher price. And then in Dallas, Texas, the federal court entered a permanent injunction halting an ozone therapy center that, again, they were trying to offer coronavirus treatment, but it was an unproven treatment. And the defendants agreed to be bound by the permanent injunction, barring them from representing that ozone could be used to treat or cure COVID-19. All right, now on May 22nd, there was a Treasury and SBA guidance that was released on PPP loans. And both Justin and Vince touched on the fact that there was an outcry relating to certain people getting PPP funds, and there was this outcry was from the public, it was from members of Congress, and everyone was complaining about what's going on. Why are these companies getting all this money when they've got millions of dollars in the bank? So going back to what was mentioned earlier about that outcry, on May 22nd, there were new rules released by the Treasury Department and the SBA relating to these loans, and so they added a couple of requirements that the PPP loan documentation must be kept for at least 6 years after the date of the loan is forgiven or repaid in full. And if the SBA determines if a borrower is ineligible, the SBA can seek repayment of the loans. And prior to this, borrowers could return funds, which in retrospect may not have been needed, by May 14th. That was kind of a safe harbor provision without a penalty, but that deadline has now passed. So now that we're advancing into May 2020, we're starting to see some enforcement actions relating to the actual PPP applications. In other words, we're starting to see the evolution from the outright fraud relating to fake treatments and non-existing products to crimes that are more heavily focused on financial fraud.
And I should note, in those types of crimes, the victim would be the government payment system that paid the money and the taxpayers, as opposed to the consumer that was being exposed to allegedly false or misleading consumer representations. Is that right?
Absolutely, absolutely. So in this very recent example, now we're into May, and that's kind of when we're starting to see this shift into the financial fraud cases. And so two businessmen were charged in Rhode Island with filing bank loan applications. Now I'm going to get into a little bit of detail because this is a very interesting case. To add some color here beyond what you're seeing there on your slide, the applications claim to have dozens of employees earning wages at 4 different businesses and sought over $500,000 to pay those purported employees. However, 3 of the 4 businesses were not even in operation prior to COVID-19 coming into effect. And here's a quote from an email from one of the principals that was obtained by one of these undercover agents working on this case. And excuse the language here because I'm going to make the direct quote from what was gained by the undercover agent. One of the principals states, and I quote, "I can create a bullshit 2020 Q1 for one of the businesses if you want, and we're going to need the same stuff for the 2 other businesses. However, we dream that up." And in a conversation with the undercover agent, one of the scammers ironically complained, and this goes back to that enforcement stuff that we were talking about earlier in the public outcry. He says he complained about the reports of large businesses being able to obtain SBA loans under the PPP, and he says, quote, "The whole thing has become a little bit of a sham." And here's the same guy is inventing 3 companies that didn't even exist to try to get over $500,000 of funds through this program. So obviously the government cracked down on that, and you saw the quote from the attorney, U.S. attorney. And then here,
Tina, can I interrupt your stride just for a moment and sort of breaking our rule about saving the questions for last? There was a question that came up on the Q&A that I think is worth addressing because it goes to some confusion around the guidance. The question is, the LA Times reported on May 13th that the SBA had issued new guidance regarding the PPP that, quote, "companies that accepted loans of less than $2 million will automatically be deemed to have done so in good faith because they are less likely to have access to other resources," close quote. And the person who posed the question asked to elaborate. And I wanted to address this immediately because Sina just correctly summarized some of the provisions of the May 22nd guidance, which, by the way, was published on the Friday before Memorial Day weekend at 11 o'clock Eastern time. And one of the points that was made in that guidance was to make a statement, and we will cover this later in the program, that in effect, all loans could be reviewed. Now I'm paraphrasing, and I'll have to look at my notes. And some commentators have said that that's a little bit at variance with the May 13th commentary or guidance that said that, look, if it's under 2 million, it's not going to receive, in effect, as much scrutiny. That guidance has received lots of play in the press without offering a firmly held view one way or the other. My sense of it is that subsequent guidance, in particular May 22nd, has somewhat muddied the water. And so I would not treat the May 13th guidance as a safe harbor at this juncture without further research. So I wanted to answer that straight away because it was, I think, connected to Sina's point about the May 22nd guidance, which otherwise did provide some useful information around repayment and eligibility or repayment certifications, which we'll talk about later. So thank you for letting me interrupt, Sina.
Okay, and here, this is actually my last slide relating to the financial fraud that on the PPP stuff. So it's a case where a Texas engineer fraudulently sought over $10 million in CARES Act SBA PPP loans. He claimed to have over 250 employees in two companies with an average payroll of $4 million for one company and $3 million for another. And there were no records of revenues or payment of employee wages in 2020 at all by this business. This is just, and the quote from the U.S. attorney is really relevant here. He says, "The behavior in this case was very brazen. Those who submit these applications for loan or other assistance need to understand that there are people checking on the representations made. And those representations are made under oath and subject to penalty of perjury. Federal agencies are watching for fraud, and people who lie and try to cheat the system are going to be caught and prosecuted." So as a final note, in these cases, we're seeing clear evidence of egregious conduct. First as to the fake and non-existing treatment, and then as to the financial fraud. But as time goes on, the government will continue its enforcement and will even begin to investigate the less egregious violations. And that's what Vince is going to concentrate on again later in the presentation. But now I'm going to go on to price gouging and other types of enforcement actions that we haven't talked about yet. So everything that I talked about so far has been fraud related. And this is now, we're going to turn to some price gouging and some just general enforcement actions that don't really fall under a generally broad category. So in addition to fraud, price gouging and hoarding have been rampant during these unprecedented times. To combat these concerns, on March 23rd, President Trump signed an executive order which prohibits the hoarding of designated items, including face masks and PPE. And relatedly, Attorney General Barr issued a memorandum explaining that the order authorizes the Secretary of Health and Human Services to prescribe conditions with respect to the accumulation of scarce medical resources. And it gave them the authority to designate any material as a scarce material. Face masks and other PPE have been deemed scarce materials, and it's now unlawful to accumulate such goods in excess of reasonable demands for your consumption, or for the purpose of resale at prices in excess of prevailing market prices. So although the HHS did not provide written guidance on what constitutes reasonable demands, Attorney General Barr explained during a press conference that he's not talking about consumers or businesses stockpiling supplies for their own operations. Rather, this is people hoarding goods and materials on an industrial scale for the purpose of manipulating the market and getting profits out of it. So if you have a big supply of toilet paper at your house, you don't need to worry. But if you're sitting on a warehouse with masks and surgical masks, then that's probably who they're going to come after. Additionally, the DOJ has created a COVID-19 hoarding and price gouging task force, and we're going to get into some of the state items that are similar to this, but you're seeing this on a federal level, and they're focusing on hotspots like New York and New Jersey. And Barr emphasized in a statement that if you're amassing critical medical equipment for the purpose of selling it at exorbitant prices, you can expect a knock at your door. So moving on here to slide 20, California has taken steps also against sellers engaging in price gouging. In California, price gouging is defined very specifically as an increase in the price of goods that is at least 10% higher than was charged immediately before the emergency declaration. I've actually run into the enforcement of this provision by local governments in certain cases, not in the COVID-19 context, but it's definitely a powerful enforcement tool that's at the disposal of the state and the local governments in this regard. And here on this next slide, we have on April 3rd, Governor Newsom of California issued an executive order which expands that protection against price gouging and gives additional tools to the DOJ and the AG's office, among others, to take action against price gougers. The executive order explicitly states that scarce medical supplies shall not be sold for the more than 10%, which we've already talked about. There's also guidance for pricing of scarce medical supplies that were not offered for sale before February 4th. And so that's something that wasn't originally in the criminal code, and it was addressed in the executive order after the fact. So now, similar to California, you are seeing that there are other states that have similar schemes. I won't go over these in detail, but states like Oregon, New York, Georgia, they all have similar price gouging laws in place, while other states like Massachusetts are having to get more creative to police such wrongdoing, looking to other statutory authority to limit the price gouging and hoarding. Now, as you can imagine, there have been numerous federal and state enforcement actions that are related to price gouging. I'm going to highlight a select few that are illustrative of the types of schemes that are being committed during the pandemic. So in New York, there was a pharmacist who was wanted for buying $200,000 worth of personal protective equipment. That's the PPE that we've been talking about, as part of a price gouging scheme. And according to the search warrant, the pharmacist has been accused of violating the Defense Production Act, which prohibits the hoarding and the price gouging. The pharmacist had told an agent, and it's crazy. He says, "I don't want anyone to see this stuff. This stuff is like gold right now. I feel like a drug dealer standing out here. So when he makes those kind of statements to, you know, an undercover officer who's trying to prosecute these things, he's kind of putting the handcuffs on himself. So that was an interesting case, and he was actually arrested again on May 26th with again similar hoarding and gouging types of prosecution.
And of course, we'll always note that statements in a criminal complaint are allegations only. And
of course,
so,
always allegations.
Alleged. We'll see how that case sorts out.
Right. So you have another couple of examples here. On April 22nd, New York federal prosecutors had charged 2 defendants for a 50% markup on masks. And then on May 4th, this one's a little bit different. On May 4th, eBay was sued in a price gouging class action, accusing it of encouraging sellers to increase the prices of masks, hand sanitizers, and other products that are in high demand during the pandemic. And one of the named class action plaintiffs was an Uber and Lyft driver, and she said she was forced to pay a 300% markup for the masks that she wanted. So that's an outstanding case, and you know they're accusing eBay of being involved in that. Here at the state level, now everything we've been talking about so far has been mostly federal. At the state level, in San Diego County, 8 individuals were arrested for price gouging after sheriff's officials said that they were allegedly charging exorbitant prices for numerous products. And again, we're talking about things like PPE, things like toilet paper and hand sanitizer, and they were charging up to 20 times as much as their pre-emergency prices. And you know, they were advertising on Facebook, on Craigslist, on OfferUp. All of these were in violation of California's price gouging laws. And here in Atlanta, you have an example of price gouging and hoarding, and people trying to take advantage of the pandemic and engaging in this type of wrongdoing. Here, a former employee of a medical device packaging company was criminally charged for conducting a computer intrusion that disrupted and delayed the medical device packaging company's shipments of the PPE. In San Francisco, there was a criminal complaint where 2 defendants were charged with committing robbery. And this is kind of like this doesn't really fit under price gouging or, you know, the other type of fraud, where we're now talking about some just kind of random non-categorical things that have been prosecuted. And so they committed a robbery in a scheme to steal merchandise from a Walgreens while claiming to have COVID-19. So they were, I guess, trying to stay away from me. I've got COVID-19. I'm going to take this stuff. That's, again, allegedly what happened. So they face a maximum of 20 years in prison and a $250,000 fine if convicted. And obviously there's restitution as well that's in the cards. Another interesting development on May 15th, again, this doesn't fall under any category, but U.S. Senator Richard Burr, a Republican from North Carolina, he stepped down as the chair of the Intelligence Committee as an investigation into a stock trading in the run-up to the COVID-19 pandemic. And the FBI has seized Burr's cell phone in search of evidence such as text messages to shed light on his very timely selling of stocks right before the information went public. And there were over $1 million of trades that happened in that time. So he stepped down as a result of the investigation. Here you have at the state level in both New Jersey and Missouri, this is again totally off the wall, individuals were charged with terrorist threats after coughing in grocery stores and making threats to grocery store employees and shoppers that they were suffering from COVID-19. So that is, again, very interesting, and you're seeing some of this, the variety in some of these enforcement actions. And lastly, enforcement actions haven't been limited to just federal or state. We're also seeing enforcement at a local level. You have the LA Attorney's Office who filed a lawsuit against an online medical retailer selling what it purported to be an at-home coronavirus test, which again, we don't have, it was a false advertising, unfair competition. They raised a lot of different allegations here in that complaint, and there was an injunction that was sought to bar the defendant from continuing the alleged misconduct. So we've already seen a wide range of different types of enforcement action. And even though the virus has only been with us for a few months, we've already seen an evolution in law enforcement action While initially the enforcement focused on fake and non-existent treatments, action later included things like financial fraud, insurance fraud, computer fraud, price gouging, and even a senator stepping down due to an investigation relating to stock trades. Now that we know what's happening in enforcement today, what can we expect from law enforcement in the near future? How can companies receiving federal aid position themselves to demonstrate compliance and manage enforcement and litigation risk? Vince will be answering these questions. So let me introduce Vince before he comes on. Vince is the chair of our law firm's White Collar Defense and Investigations Group. Before joining JMBM, Vince served an assistant U.S. attorney in the major fraud section of the U.S. Attorney's Office for the Central District of California. In that position, he investigated and prosecuted white-collar crimes, including healthcare fraud, bank fraud, mail fraud, wire fraud, bankruptcy fraud, every type of fraud you can imagine, and money laundering. Before becoming a criminal prosecutor, Vince was an AUSA in the civil division of the U.S. Attorney's Office, where he represented the U.S. in commercial litigation and other civil cases. He also served as a law clerk to the Honorable Edward Graffiti, a U.S. District Court judge for the Central District of California. I will now turn the program over to Vince.
All right, thank you, Sina. And if people do have questions, please feel free to put them in the Q&A, and we can break up the monologues here that we're doing. So what can we expect in the future? Obviously, one of the takeaways from this presentation is that there are significant strings attached to the receipt of federal relief funds. This is true whether it's a loan or a grant. Those strings can be very problematic. And to frame where we think this is going, we'd like to make the point that past is prologue, that old saying. Although this is an unprecedented pandemic in modern history, certainly we've seen other situations. And we really can look back to the 2008 financial crisis to give us a sense of how enforcement may proceed going forward. Government financial fraud enforcement in the wake of the 2008 financial crisis is a good indicator of what we can expect. After the 2008 crisis, we all remember that Congress established a special inspector general for the Troubled Asset Relief Program. It was called SIGTARP. And SIGTARP was meant to deter fraud, waste, and abuse relating to the Troubled Asset Relief Program, which helped stabilize the country's financial system. Now, bear in mind, although at the time TARP seemed enormous, it made $700 billion available to stabilize the economy. That's really dwarfed in comparison to the amount of money we're talking about here, over $2.5 trillion. But through the Special Inspector General, through SIGTARP, there were a number of investigations that led to the recovery of about $11 billion and prison sentences for hundreds of defendants through the enforcement actions that were brought by a number of different regulators, including the Department of Justice and special inspectors generals. It was, the special IGs were set up to oversee billions of dollars of funds unrelated to the financial crisis, allocated for projects to rebuild Iran and Afghanistan. So you've got the SIGTARP prologue as well as the special IGs. And as the slide indicates here, these special IGs recovered nearly $200 million in funds and resulted in a number of convictions. We can expect similar, very rigorous scrutiny as to the funds that are distributed through the CARES Act. As with TARP and the SIGTARP investigations, businesses should expect strict enforcement scrutiny involving CARES Act funds for many, many years after the pandemic has subsided. Obviously, also, the amount of money involved in CARES Act is much bigger than TARP. We're talking about trillions, not billions. Another way to understand the sheer scale of the federal government's intervention in the economy in this pandemic and how it creates enforcement risk for companies is looking at what's being done by the Federal Reserve Bank. The central bank's portfolio of stimulus-related bonds and loans and new programs is estimated to grow between $8 and $11 trillion. That's with a T. And that's compared with less than $4 trillion last year. So a Fed portfolio in that range would be roughly twice the size reached after the 2007-2009 financial crisis and is nearly half of the value of U.S. economic output. So it really sort of boggles the mind the amount of federal money going into the economic system. The Fed's corporate program of corporate buying is already starting to kick in. It started earlier this month. The central bank, for example, tapped BlackRock to help it direct money into both new and already issued corporate bonds. And this assisted the Fed in its new role as a lender of last resort. And that's a relatively new role for the Fed. The Fed also tapped PIMCO to help the central bank buy commercial paper, which is companies' short-term borrowers. So this unprecedented level of federal stimulus means that companies should expect an unprecedented huge wave of law enforcement activity for many years to come. Let's move to the next slide, please. Thank you. So obviously a program that's received a lot of scrutiny, and we've seen seen as enforcement roundup a lot of enforcement actions, is the PPP program. Applications for SBA loans are submitted under penalty of perjury with representations regarding full truth and accuracy. You can see on the slide here that PPP loans are going to be audited, and the main areas of risk are whether the loan is necessary, size eligibility, the use of the proceeds, and the like. And SBA is going to want borrowers to consider these certifications. For example, PPP regulations have a requirement that 75% of the funds go for employee salaries and no more than 25% on rent, mortgage interest, and utility payments. Now, this 25% cap, notably on non-payroll expenses, is not included in the CARES Act itself, but was imposed in the regulations crafted by the SBA and the Treasury Department. I think there was some hope that in the May 22nd guidance, there might be some relief from the 75-25 rule, but the government has maintained that rule going forward, and so we still have to deal with that 25% cap. And the recently released guidance confirmed that if funds are used for unauthorized purposes, borrowers have to repay the loans and could be subject to liability for retaining those funds. As Sina has pointed out, the safe harbor period has passed. An area of certification risk is needs-based certification. And that's really where a company, if they want to convert a loan to a grant through the forgiveness process, that's really going to impose an obligation on the company to certify accurately. And as I mentioned earlier in response to our question, on May 22nd, the new rules that were issued made a statement that the SBA may review Paycheck Protection Program loans, quote, of any size at any time in the SBA's discretion. So that appears to walk back the earlier guidance that was referenced in the question before. Companies have an area of compliance risk, and this has to do with the quote-unquote necessity certification. And the language for necessity is, quote, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. And of course, that language includes the words uncertainty and necessary, and there's very little guidance as to what those terms mean. So there's potential compliance pitfalls there when you're when you're certifying uncertainty and whether it's necessary. There are specific calculations to be used in determining the amount of the loan. The May 26 guidance has some additional detail. There's a $100,000 salary cap for payroll calculations. Borrowers have to provide backup for their payroll claims. So you should take a look at that May 22nd guidance for the latest information. But again, the burden of compliance is on the borrower, on the company, not the lender and not the government. In addition to certifications around loan amount and the compliance issues around that, there are strict rules regarding the loan forgiveness, and there are statutory mechanisms that could reduce the amount of forgiveness depending on the borrower's actions during the 8-week period following an origination. So you should look carefully at those rules. On May 15th, in one of the many guidances, the SBA produced a schedule, sort of a sample schedule that borrowers can use to document their use of the funds. And that can be a helpful guide, and I would encourage people to take a look at that guidance, at that checklist or that schedule if you're planning to seek loan forgiveness. Next slide, please. There was a question posed in the chat about payroll taxes and whether the taxes themselves are included in the 75% calculation. That may be the case, but I'll have to check the guidance and get back to you. So if you want to send an email after the program, we can follow up. This next slide talks a little bit about the SBA loans and the SEC crossover issues, as well as an issue that we've seen raised in some commentary and news reports about online conferencing. Obviously, in this crisis environment, lending decisions are made very quickly. The government's going to be relying and is relying on the representations made by applicants. As I mentioned, this recent guidance has clarified that lenders have very minimal requirements to independently verify applicants' eligibility. It's really an as certified as presented. So representations made on applications could form the basis for civil and criminal exposure for statements that are later proven to be materially false. There are a number of items on the application: the total number of employees, the payroll expenses that, if filled out incorrectly, whether mistakenly or intentionally, could lead to an investigation. Now look, most applicants aren't going to outright lie on these applications. The cases that Sina summarized, many of those involved what we would call obvious cases of lying, cheating, and stealing. Sort of classic fraud where you've really got fake representations with no underlying basis in fact. But most applicants are not like that. Most applicants are business people trying to make decisions, looking for these loans as an opportunity and these grant programs as an opportunity to keep their businesses afloat. And they're having to navigate, oftentimes without the benefit of counsel, rules that seem to be changing every day. That's where we're going to have problems in the future. Now, these PPP loan applications make it clear when you sign those applications that if statutes are violated, there could be problems down the road. The application actually identifies certain statutes. It identifies 18 U.S.C. 1001, which is a false statement statute, 15 U.S.C. 645, misrepresentation statute, 18 U.S.C. 1014, which is false statements to a lending institution. Federal prosecutors are also fond of using other charging statutes like the criminal false claims statute at section 287, the bank fraud statutes at section 344, and mail fraud and wire fraud 341, 343, and criminal conspiracy 371. These are all in Title 18. Prosecutors regularly use these as sort of trusted go-to charging statutes. If there's an allegation that a loan might have been obtained through bribes or kickbacks, there could be prosecutions based on bribery statutes, such as 18 U.S.C. 2015. In addition, we have SEC enforcement. The SEC is ramping up enforcement related to the volatility of the market surrounding the COVID-19 crisis. There's already been a surge in SEC investigations relating to fraud and disclosure requirements by companies, including the possibility of private shareholder lawsuits stemming from that. Just today in Law 360, it was reported that the SEC is fielding a spike in what they call tips, complaints, and referrals. Tips, complaints, and referrals, they call them TCRs. And the SEC fraud, one of the fraud enforcement chiefs said that to date, the SEC has issued more than 30 trading suspensions and that they've seen a spike in TCRs. So it's something to think about. The SEC enforcement piece of this is critical. And if you're working with a company that's publicly traded, that's an additional layer of enforcement risk that you need to be concerned about. Before we move off this slide, a point about video conferencing. Obviously, right now, our entire economy seems to be run on platforms such as Zoom, Cisco's WebEx, Microsoft has a platform, and we've seen some news reports and some commentary that in the immediate aftermath of the sort of pandemic, as companies were considering whether to take aid and to apply for aid, that a lot of these sessions might have been, as we all know, these online platform sessions allowed for the recording of those sessions. We've already seen requests by law enforcement to companies for copies of those recordings. So if your company uses online video conferencing, you should consider developing a compliance program that establishes the do's and don'ts of when sessions should be recorded, because those recordings could be evidence in a future audit or investigation. Next slide, please. These next two slides, I want to briefly cover two very large civil enforcement tools that the government has. In addition to criminal remedies and civil enforcement remedies by the SEC, the government has the False Claims Act. And on the slide here, we have sort of the basic elements of what is a False Claims Act case. And this is a statute that government contractors are very familiar with. But companies that don't typically do business with the government may not have a lot of understanding about the risk management. So if you do business with the government, if you present claims for reimbursement, those claims, if they're deemed to be false, and this is a civil statute, so it's a preponderance of the evidence standard, not a beyond a reasonable doubt. And it's a much broader standard of potential knowledge. It doesn't just include actual knowledge and intent to defraud, but it can also include reckless disregard, so a much sort of broader category of potential scienter. And what has happened is that these applications for PPP funds, when you take the money, and more importantly, if you seek forgiveness and you don't repay that money, that creates compliance issues and potential exposure around the False Claims Act. There's also what's called the Reverse False Claims Act provision, that if you knowingly withhold money that you shouldn't retain, you can have False Claims Act liability. Before we move to the next slide, 2 points about healthcare companies and lenders. As Justin mentioned, in addition to PPP, there are a series of grants that HHS gave to healthcare providers. There's an HHS relief fund, and you can go online and look at a database of healthcare providers that have accepted this money. Unlike loans that were applied for, some of these providers literally woke up one day and found money in their bank account, and then were asked by the HHS to certify that they were going to use those money. And this is really a whole different area of potential False Claims Act liability, and the certifications are the strings attached. And so healthcare companies that have received those funds, and they've come out in a series of rollouts and tranches, need to be mindful that their certification, attestation and certification around receiving and using those funds could create potential liability. And if you're a healthcare provider and you're currently involved in a billing dispute with Medicare or in an overpayment dispute with Medicare, if you're dealing with CMS or have other fraud allegations, you should make sure that you're mindful of those enforcement actions that you're dealing with in light of receiving additional funds. Keeping CARES Act money in violation of the government's attestation and certification requirements really could create the basis for liability under the False Claims Act. The other point you should be aware of is HHS for healthcare providers added a certification paragraph to all its relief funds terms and conditions, requiring certain additional certifications that relate to criminal and civil penalties. So you should take a look at that if you're a healthcare company. With respect to commercial lenders, federal agencies originally agreed to hold banks largely harmless if they relied on, in good faith, on borrower certifications and supporting documents. So it seems less likely that there'll be wholesale investigations of the banks themselves, but lenders should be mindful that they could be subject to investigation and prosecution if their own employees are alleged to have conspired with applicants to fraudulently secure CARES Act loans. After the 2008 financial crisis, again past its prologue, there were investigations of bank employees that were alleged to have been complicit in obtaining fraudulent mortgages. Commercial lenders could come under scrutiny if government investigators uncover a significant amount of fraud associated with a single lending institution. So if they look at a lending institution, they appear to be a hotspot of fraud, that could subject a lender to scrutiny. So something to bear in mind, a lender shouldn't take 100% comfort in the fact that there's a limitation of lender liability. Next slide, please. The other powerful civil enforcement tool that I wanted to bring to your attention is what we call FIREA. That's the Financial Institutions Reform, Recovery, and Enforcement Act of 1989. That's a mouthful. It's called FIREA. This was enacted following the 1980 saving and loan crisis. It's a civil statute, but it was largely dormant for many, many years until the late 2000s. And as government prosecutors began bumping up against the statute of limitations to bring criminal fraud cases, they began to look to FIREA, a civil statute, as a charging tool. It's been said that the U.S. Attorney's Office Civil Division here in Los Angeles was an instigator of this. If you will recall, the large-scale civil cases involving Countrywide, a successor, Bank of America as the successor in interest to Countrywide. A number of those Countrywide cases were actually FIREA cases that were worked jointly by the Department of Justice and the U.S. Attorney's Office. And some have said that the Civil Division Chief, Lee Weideman, was responsible for sort of dusting off that statute and using it. I don't know for sure if that's the case.
Okay, it looks like we've lost Vince again. I know time is starting to run out here. Let's see if I could close it out here after the FIREA discussion. Here on the third-party liability issue, COVID-19 enforcement, it does raise the specter of the companies facilitating the sale of exorbitantly priced product and providing means for the mechanism for others to engage in fraudulent activity may be exposed to potential civil and criminal liability. Oh, and here we go.
And once again, the vagaries of working from home, my apologies. And that's also probably a sign that we're about to go over time, so I'll pick up the pace. The third-party liability that Sina was just talking about is another significant area. We want to be mindful that in the case of this, we have actually some cases involving voice over internet protocol technology companies that have received basically letters from the FTC. We're also seeing consumer class actions, a very big area. One of the questions that we've gotten in the past is, can companies expect relief in terms of relief from potential liability? There's been some talk about passing legislation, federal legislation, to cap the liability of healthcare companies, employers, and internet providers, or not internet providers, but social media companies. And the Chamber of Commerce has commented that the wave of employee lawsuits that we're expecting could be a big area of concern. However, others have commented that they're, in fact, we don't want to put consumer protection statutes to the side, and we certainly don't want a situation where consumer protection is not maintained. And so my view is that companies shouldn't hold their breath. We shouldn't hold our breath waiting for liability protection. We've got to be ready now. Employee lawsuits are another area where we can expect a big increase in litigation. Why is this? Employers, companies are in uncharted waters when it comes to occupational safety and the economy. Jobs are scarce. The plaintiff's bar has been on shutdown like the rest of the lawyers. And I do think we're going to see an uptick. One example that we saw recently is a Superior Court case filed against the dealership based in Pasadena. The ex-sales manager filed an action. He was apparently terminated at some point. He filed an employment action alleging that he suffered a backlash and was fired after complaining that management failed to take steps to protect employees and customers during the COVID-19 pandemic. And so he accuses the company of retaliation, violation of the California Family Rights Act, and discrimination. So in addition to government enforcement litigation, civil and criminal, we also have an increase in private litigation and class actions. Next slide, please. And this is a slide about class actions. I won't go through and read these. I know we're tight on time, but we've seen some of these advertised in the media. Class actions against Carnival Corporation, against educational institutions, against Amazon for price gouging. And I think that we can expect a robust number of class actions ranging from consumer frauds to employment claims based on layoffs, financial losses, and the like. I think this is just inevitable. Next slide, please. One last point before we close to some practical guidance for companies is a virtual town hall that was held last week. It was a virtual town hall that the participants were the chief of the DOJ fraud section, the senior deputy chiefs of the fraud section of the Department of Justice, the chief of the SEC's FCPA unit, Foreign Corrupt Practices Act unit, and the chief of the FBI's International Corruption Unit. They did a virtual town hall And like oracles, they proclaimed that yes, there's been a slowdown in some enforcement. Not having access to grand juries and not having access to in-person interviews has been problematic. It has hampered investigations. However, they made it very clear that the FBI is able to get search warrants pretty easily. They can use a remote conferencing with judges. They're doing interviews and proffers via phone and teleconference, and they made it very clear that the healthcare fraud unit in particular is looking at schemes where persons are seeking to exploit the pandemic, where they're offering free testing in an effort to obtain personal identifying information and billing information for Medicare beneficiaries for supposedly unnecessary services. The SEC has also developed a steering committee and is coordinating their efforts with federal and state agencies. And I mentioned earlier about parallel proceedings. We can expect parallel proceedings between criminal and civil investigators at the SEC. And during the town hall, these enforcers said that the current environment is ripe for securities violations and market manipulation. And so that's something we wanted to share with you. Last slide, please. This is the final slide. And obviously, our sort of message here is that we are moving beyond the obvious cases of lying, cheating, and stealing. And we're now going to be looking at cases involving the gray area, where companies acting in good faith are going to be audited and investigated in situations where they might have unintentionally or unknowingly made statements that turned out to be not accurate. You know, nearly 75% of all the loans in the first PPP wave were for less than $150,000, and 90% of the second wave of loans were of small size. And this suggests that most of the applicants were small businesses that don't have extensive compliance teams, don't have in-house counsel. So what's our message? Be ready, and tell your clients to be ready. Companies that take government money have to be proactive in documenting their eligibility and their compliance with government requirements. I have sort of a 7-step process. This is by no means legal advice. This is just a way to organize your thinking. The first step is work with clients to get a firm grasp on the specific criteria to qualify for eligibility for the program. A practice pointer, unfortunately, the May 22nd guidance doesn't give us any further clarity on eligibility, and so we have to use our common sense and follow a rule of reason in advising clients. The second step is to understand the specific conditions for receiving the federal funds. What are the attestation requirements? What are the certification requirements? The third step is to carefully document the decision itself to apply for government aid. So, for example, document the company's current business activity and how it was negatively impacted by the pandemic. What was the downturn in the business? Document that. Keep track of the business projections that were made in deciding to take out the loan. You know, what were your projected payroll needs? Document that there was no alternative source of liquidity. Document those things as part of this third step. Fourth, carefully document how you spent the money. Employee counts, compensation levels. Keep contemporaneous receipts and logs. After the fact records are viewed more suspiciously by investigators than contemporaneous documentation. In terms of practice pointers, the PPP loan forgiveness application posted on the May 15th website alert does give a detailed schedule. I think that's helpful. One thing that we get a question is about document retention. And as I understand it, the May 22nd guidance indicates that borrowers have to retain their PPP documentation for 6 years after the loan is forgiven or paid in full. So 6 years is a long time. Be sure to document make sure that you adjust your client's document management destruction policies accordingly. Fifth, if you don't already have them develop written standards for employees to follow. Sixth, train your relevant employees on the relevant standards. And seventh and last, create an internal monitoring system that regularly tests whether the company is complying with the rules and regulations on the government programs that the clients accepted money from. You know, it's been said that money is fungible, but government investigations follow the money in a straight line right into the business and right out of the business. I've seen that as a prosecutor, and I've seen that as a defense attorney. So following good compliance practices now will help companies with any audits or enforcement actions in the future. And as the old adage says, an ounce of prevention is worth a pound of cure. So that is our presentation. Our email addresses are there. I do encourage, if you have questions or want to talk about these matters further, reach out. We're happy to consult. And we're very grateful for the opportunity to have made this presentation and to work with the Beverly Hills Bar Association. And so with that, we'll thank you for your time and thank you very much for listening. Bye-bye.
Thank you.